You're listening to the Valley Current.
So let's spend a few minutes talking about the complexity that's here, just so everyone knows this. Well, welcome, Arpita. I guess you're back from becoming a mom of a few months. How many months is it?
Yes. Yeah, 3.5. 3.5. Yeah.
How does it feel 3.5 months later?
She is very sweet and calm, at night. Nighttime is the toughest, but now it is fine.
Okay. So we'll talk separately after this meeting. But let me just tell you, so just to get Arpita a bit up to speed, you may remember we had this case against these ex-employees. We actually won a pretty good set of rulings, I guess. That's caused some movement towards actual payment. And now you got the problem of how do you make sure you get the payment? Because they're not actually coming forward with a bundle of cash. Now, my first question is, why can't they go to a hard money lender? We did the calculus. I don't know if Max is on the line, but he looked at the numbers. I looked at the numbers. We made some assumptions. I think Linyan, me and Max looked at the real estate stuff, and we said it looks like they've got like $6 million. Now, that's not all Ken and the CPA. What's his name again? So Max, I don't know if you could quickly eyeball, because you'd have to take out, you have to take these other defendants out. What is the real estate that? And
okay, I'm gonna go look at the numbers, but I know that, and I are the ones that have the really expensive properties, but like small properties.
Okay, good. So maybe then the answer is, instead of $6 million net equity,
let me go check real quick.
It's more like pick a number. Now, what's complexity number two? You take out the non-settling defendants' real estate. Does that change our view about trying to get security and a standstill? They haven't agreed to a standstill, right? Isn't that the current?
Yeah, I guess what's confusing me is if there were enough equity for the two people that want to settle, if there were enough equity there, and we got liens on it, then I mean, unless we're worried about the market going down, I guess that's a reasonable risk. They can't get out of those liens in bankruptcy, can they? That secured liens are not just.
But we don't actually have the liens. We don't have them yet.
Well, I know, but that's the point. Is if instead of
the agreement.
In other words, if we just had a simple settlement agreement that says you will do this, this, and this, and some of it is putting second or third deeds of trust on the property, isn't that a simpler way to?
No, but Joe, the way that works is if they file within 90 days, those get stricken. In bankruptcy, anything that happens 90 days.
Oh, because of the preference, I see.
Yeah. You have to imagine.
Okay, I get it. Yeah.
Like, let me give you the real deal that wouldn't be blocked by that 90-day rule. I'm a hard money lender. You want how much cash? Oh, I want $3 million. What real estate do you have for the $3 million that I can loan you in a concurrent deal? All right, I got it.
Yeah.
Right. That's why getting an actual hard money lender, like, let's pretend it is the hard money lender. He's got a lot of money. Or let's say got a lot of money and he's the hard money lender. And you bring in that third party to say, look, these guys have whatever Max or Linyan will report is the
calculating for
because let me tell you what step two is. Step two is they've now segregated the smaller real estate guys out of the mix. Those real estate guys may be like ready to do some deals with the lawyers, keeping in mind whatever is their homestead, to try to prevent any reach over that real estate, right? Like maybe this is one of those deals where there's a little bit of, cut and slice. Now here's step three. What happened to saying he was worried that these guys had all these investments and cryptocurrency and all that jazz? That's going away as well, right? Isn't it, from this?
Well, yeah, because he's decided that if he can get $3 million in cash, he's happy, which is, I mean, keep in mind, you know, the $3 million in cash is on top of the 1.4 and the 1.2. So he's going to end up with $5.5 million. If he gets that, he's ended up $5.5 million out of this thing.
Well, how? How is he going to get that? The judge is not going to.
The $3 million. Well, I mean, that's his goal. Is what I'm saying. Is his goal. If he could get $3 million, he's going to give up his tracing and all that.
Okay, so now let me tell you, just as like the little educational moment here, if there is one, my read of the change in sentiment is and have negotiated with the board some type of bonus if the year-end numbers in cash or in what can be bookable revenue are above a certain amount, and that's why this $3 million is magical. Do you follow what I'm saying?
But they're not going to get the whole $3 million before.
Oh, but they get to book it. They get to book the settlement as though, hey, we've made a deal with a certain degree of certainty.
All right.
Do you follow what I'm saying?
But you're telling me that so rich that how much could that really benefit him? Maybe.
Well, just the whole management sentiment changes. Management sentiment has just changed from last week. I mean, maybe it changed for other reasons, but to me,
I think it changed because he didn't expect to get the full payment from them. And now they're saying, we'll pay you the whole $3 million.
Kim, why wasn't there the snotty typical remark? They must have billions in cryptocurrency then if they can do that.
Because I personally, I think that he's probably given up on that at this point, because if they really have that much money hidden somewhere, they would have settled this a long time ago, because this kind of thing hanging over their heads is going to destroy their lives.
Yeah.
I mean, you can't just go around with $1 million judgments and expect to keep your job and whatever else semblance of real life you have.
Yeah. I mean, it could have been a sobering moment. Look, they might have gotten the bill from all the attorneys. If you're the attorneys that generated this shitty outcome, you generally get your end of month bill in early or quickly, or end of year bill in, right? Because you're like, I want to get paid. So that's when the sobering moment happens, which is, holy shit, we have to pay you as well. And somewhere in this, maybe one or more of those attorneys said, well, you don't do that, then we do no further work. So maybe you should have us reach a settlement that'll give you time to exhaust those real estates, right? To sell. I don't even think they're going to sell. I think they're going to try to get refinanced. That's my guess of what's going to happen here, right? So the second question is, once you're back with some number of what is this net equity worth, then the next question is, who's the hard money lender? And then the third question is, what would that lender do? Because that's the real assignment now for the term sheet. The client is putting himself in the role of being the hard money lender, when you've almost have to tell him as a first instance, the very first thing you can do is get a hard money lender to loan these guys the money and get paid concurrently, because that's the only certainty in life, is the cash passing like instantly. And then I imagine if the cash passed instantly, the interesting question would be, phase 2 is over, right? And I guess the award itself gets locked up in a vault somewhere, that an unbreakable vault, something that can never be opened again, right? Is that right? Is that the outcome? I mean, what's the answer to that? Yes, maybe, I don't know.
Well, I think the answer is yeah. I mean, the answer is it never becomes a public judgment, and I guess there's some agreement not to publicize it.
Right. The case is over for $3 million or whatever round number is. Not $3 million plus another 2.5. Right. 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 They're not playing that game here. They're not going to pursue and for whatever might be a residual, right? realistically.
Right, because what you would want is if you could get the cash from the other two, you get the cash from the other two, and then if those guys want to go after their compadres there, then they can go after them for contribution, for indemnity.
Well, they'd have the right to go after them even on this settlement, right? Because they're overpaying, aren't they? In their view.
Well, that's what I mean. In other words, you get the money from two of them, and then you say how you guys got us this money or how you end up going after each other is your problem. All we wanted was the money. Now you guys, we're done with you guys. You guys go work it out among yourselves as to whether any of you owe each other money. That's the easiest way. But the problem is getting the $3 million because they're saying they don't have $3 million. And so that's what we're struggling with is if we only get 750, how do we make sure we get the extra 2.25 without losing our rights, in bankruptcy? I mean, isn't that the real issue that we're just struggling with?
Right. So let's pretend we're being super savvy for this hard money lender. I'm not even going to call it FFN. I'm just going to call it hard money lender. Hard money lenders sometimes say, look, we're going to hire a lawyer to implement like a bankruptcy-like lawyer or creditor's right lawyer to implement all this paperwork. And you're going to pay for it because this is a cost of the loan. So why isn't the right answer to include parties to jointly hire an outside bankruptcy expert to absolutely ironclad this thing? Not Computer Law Group, not Jack Russo, not anyone else, just an outside super bankruptcy expert who knows all the bankruptcy judges and who says, yeah, I know exactly how this stuff goes, and this is how you make it ironclad. Because that's where my head is leaning right now. Because I
agree. I agree that we ought to somehow get bankruptcy advice because, I mean, I sure as heck am not qualified to give bankruptcy advice.
It's a moving target too, because the bankruptcy judges have a certain degree of equitable power to sort of marshal assets around, right? So they might say to John, you'll get your money. It may take 4 or 5 years. This actually happened to one of our clients. We win a judgment after a trial, and the client goes to his wife and says, I'm sorry, honey. The defendant goes to his wife and says, I'm sorry, honey, I just lost this case. This guy, Jack Russo, pulled a rabbit out of a hat in San Jose. And our estate, our marital estate, is going to get tagged for $1 million. And the wife's like, no, it's not. I'm getting a divorce. I swear, Joe, this happened. This actually happened. And the divorce lawyer was like, yeah, that's not our problem. And you owe the wife most of the marital estate. So we're going to go in front of a friendly family court judge and pretend like this judgment didn't happen against you and get a judgment entered that says the wife owns the house and owns all the personal property and you get nothing.
That happened in California?
Yes. And we had to chase and ultimately hire for the client, or the client hired for themselves, a bankruptcy lawyer, and ultimately pursue a fraudulent transfer case against the wife for this bogus it was a genuine divorce. She actually testified she hated her husband before he did this stunt, before he lost in court. That in her mind, the divorce was long overdue, but this was like the stick. This was
kind of precipitated it, though.
This was the stick. This was the stick that broke the camel's back. It was really funny. Like in this deposition record, every indiscretion that this guy ever did was like another stick. And like, I could put up with this, I could put up with that. It's like, this is like the funniest video deposition you ever want to watch. It's like so funny. But she said that was it. And you know what? We ultimately won against the wife. And
it wasn't a community debt. It was.
We had to win that, though. We had to win that argument, and then and only then did she actually forfeit over through a hard money lender who loaned against the house? Because I said, this client's not going to take any more promises.
Yeah.
So that's another case that's sort of an example of essentially you don't really want to be the hard money lender, because the hard money lender would charge a fortune for this deal.
Well, the other thing is if, I mean, when you say FFN being the hard money lender, I mean, if we tried to do that, wouldn't it just be set aside as sort of a sham and just a way to try?
I want to get like a separate Andrew Conru company from Seattle, Washington. Andrew Conru is a majority shareholder, whatever he is. He has entities that loan money out. He could be the hard money lender.
But I'm just asking, I'm not expressing an opinion. I'm just asking, is it possible that if it's a related entity, they could try to set it aside as a sham in bankruptcy to get around the preference point that you raised?
Okay. So maybe your point is get a real hard money lender. Like
that would be better, but who's going to lend them that money? I mean, that would seem like getting a $2 million loan is not going to be particularly easy unless their real estate is really, really solid.
Well, if the real estate is solid and you think that they're going to be current on the first or whatever is ahead, because all this real estate is encumbered, right? Right, Max? All this real estate is encumbered. It all already has trust deeds on it, right?
I believe so. It's a little bit interesting because he's the only owner, but I'm pretty sure there has to be some encumbrances.
Yeah, because
what do you mean he's the only owner?
When you look at the title report, he's not jointly. He's the only, just no secondary owner or
no spouse. Maybe he's got no spouse. Maybe he's already gone.
That's not a title report, is it, Max?
No, it's a preliminary. It's like a preliminary.
I was just sitting here thinking that maybe we should get real title reports.
They're pretty expensive. I mean,
if we're banking on this property being worth.
No, that's where you get this whole point of they pay for the outside implementer of what might be called, like, here's the assignment, Mr. Expert Lawyer on bankruptcy. We want 99.9% protection in the event that any bankruptcy happens by any of these defendants, any of them. So we want to know that there's going to be assurance that the liens will be good, this will be good, that will be good, blah, 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 blah. And we will get priority status in the event. And I think the answer probably that's going to come back is you're never going to get 99.9% unless you get a true arm's length outside lender who delivers cash at closing, and that lender takes over this collection risk because they negotiate this deal with all the points and all the expenses that go with it. And that's the hard cheese for someone like Ken and someone like Lynn, which is, God, that's a lot of expenses. This could be like a $50,000 legal bill. And with all the title reports and everything else that goes with it, right? Because you want the certain level of certainty that there's going to be collection here, right? I mean, that's really what it comes down.
On the real properties that Wynn and McCoon have, are they encumbered with more than like a first deed of trust, or are they pretty clean?
I think they all have at least a first. I think he's really asking, Max, are there any seconds or thirds or that sort of thing? And by the way, this is another moving target, because even as we talk about it, they could be in the process of putting a second or third on for the lawyers, right? And then buying time. Because
but if it's somebody, if it's a bank, then it's a bank. You're not going to get a subordination agreement from a bank. But if you had other seconds that were sort of related to them, like lawyers or something, you might be able to get. Oh, so
you just added another paragraph. Lawyers will agree to subordinate all legal fee debt behind this judgment, right? Because that's another thing that can happen between now and the 1 year period. Right? Because once you give them a 1 year period, if they're not in some standstill, and they obviously haven't signed the standstill, right? They're obviously contesting this, right? Isn't that what's going on? Even while they say with the one hand, we want to settle, isn't the first thing John should have done is to say no negotiations unless we have a standstill, at least by the two of you? Isn't that what he should have done?
I mean, that would make sense. That would make sense to the two. The other question I have is, what's the deal with the other the people that don't want to settle? I mean, why would they not want? I mean, maybe they don't have a lot of money, but why would they just not want to settle it?
Because they don't want to do the disclosure and they don't want to have some dollar commitment. Like they're just looking at like, it can't get a lot worse for us. And these two guys are thinking it can get a lot worse for them. There's a risk tolerance difference, right?
Those other two guys have jobs? The other two?
Yeah, they have jobs. They all have jobs. All of them have jobs, Joe. I mean, the other possibility that's out there is the Berliner folks said, look, if we belly up with this down payment idea and then payment over the next year or so, it'll basically go away. And that may be true. Isn't that what's sort of happening, oddly enough? John's sort of saying suspend the case. I don't think he's saying go forward with phase 2 as against just these stragglers, right? Isn't that's the way
I didn't hear him say suspend the case, but
no, I don't think so.
There's no suspension.
Maybe there was some secret code that you guys speak.
No, well then how do you not stop the fee burn that he's complaining about? How do you not stop the expense? Like how do you not, like in an oddball way, how do you not just say to these guys, look, we're going to make sure we try to get maximum coverage against your net worth, because we're taking out what probably are the biggest net worth players in this, right? These two guys probably have the largest net worths. That's another reason for them to want to not be part of phase 2, right?
Yeah.
If their net worths are both, $5 million apiece, and the net worth of the other guys are more like $1 million apiece, then the punitive damages risk is a lot higher for the two of them, isn't it? Separately speaking, what do you think the take should be on this motion, on this this motion to reconsider it? What's the justification for this motion? Is there actual justification?
I mean, come on. I mean,
no. What's the procedural? What's the procedural justification? Is there a rule that says you get to relitigate the case?
Well, there's a rule that says.
There's a rule you can.
Yeah, there's a rule that says that you can try to make a motion to set aside mistakes. I mean, I guess. But
the law on that is mistakes on the face of the award, like a mathematical error. The numbers don't add up. Look at the law on that. The law is not you get to relitigate the case. You don't get to say, let's retry the civil RICO. You found all the elements and you mistakenly didn't realize there were two victims. That's not the
then
law.
He can say no. I mean, he can just deny it.
No, but the procedural defense, I think, is pretty simple, which is if we pull the case law, it's really simply along the lines of the applicable JAMS as well as the applicable AAA rule. And I think the rule in judicial arbitration under the CCP, it's got to be an evident on the face of the ruling kind of mistake, because mistakes of fact and law are not reviewable. Like what's entered as an award is really gospel, even if it's wrong. So that's worth Taylor shifting from whatever you're on to focusing on these rules. Does someone have in mind what the rule is? They're like Rule 36 or Rule 38. There's a rule dealing with mathematical mistakes, that sort of thing. There's a JAMS rule on this. But there's also, I'm telling you, there's also case law on it. And the case law is pretty tough. Like the case law basically is we don't want this sort of round 2, round 3, round 4. We don't even want the U.S. Supreme Court just ruled that RICO applies when there's a single victim. Like even that would be like, sorry, you missed that boat by a few months. That rule was not the rule until now, and you tried your case already. Like literally, it's at that level. Does someone have the rule up? Does someone have the JAMS rules up? Like,
yeah, hold on a second.
Why don't you put them on the screen just so we show people how you go through this kind of analysis of these rules?
Does somebody have them up? Where's the share?
Jack, I'm going to send you a draft of the memo with the 6 questions that you have asked, and I've gotten through most of it, and it actually addresses a lot of the issues that we're talking about, I believe. But it's not fully completed. But I'll send you the SharePoint link to the current draft.
Okay.
But then I can shift to this other researching this other issue. Right.
So isn't there something dealing with maybe it's in Rule 24 on awards? Are these the GEMS rules, right?
Yeah. Okay. All right. Let me try to get to 24.
I mean, what about the allocation of the arbitrator fees? Shouldn't that be loaded into these numbers? Shouldn't they have to pay that? Isn't that like another 100,000? I mean, these guys are rushing so quickly without asking any questions, right? I think we automatically get at least those as costs, don't we? I mean, that's what my argument would be.
Oh, here is this what you're looking at, Jack J? Here, within 7 calendar days after service of a.
Yeah, correct any computational, typographical, or similar error. I mean, that's not a substantive error. That's like the numbers don't add up. There's typos. I mean, we actually have a few typos in this, right? Don't we?
Yeah, but they're not really that.
Not worth pointing out. Or the arbitrator may sua sponte correct such errors, not any error. Then it says the arbitrator may make any necessary and appropriate corrections. Maybe that gives him some discretion within the 21 days of receiving a request, or 14 calendar days after his or her proposal to do so. They extend the time within which to make corrections. I mean, I don't know if they're talking about if the beginning sentence kind of limits it to just those 3 categories. That's what I would say, such errors. And then instead of saying the arbitrator may make any such corrections to such errors, it says may make any necessary and appropriate corrections.
Yeah, of course, this is also an interim award, so I don't know.
Well, it says partial final. Oh, doesn't apply because it's not a partial final award yet? I think it is kind of a partial final.
Partial final award after okay, yeah, any party may serve upon. Within 7 calendar, did they do that within 7 calendar days? It was the thing was served on November the 4th. When did they file their? So that, yeah, I guess they probably did.
They did?
Yeah, because November the 4th was a Thursday, right? So Friday was 1, and then the next week was 6, and today is the 7th.
Why isn't it 7 calendar days from the 4th? Is the 11th? Today's not the 11th. Today's the.
Oh, wait a minute. Calendar
days, not business days.
Not business days. Okay, yeah. So they're late to begin with.
Yes, I think that's the first bullet. The first bullet is they're late. The second bullet is it's not a computational error. The third bullet is it's not a type, or maybe the second bullet is not a typographical error. The third bullet is not a computational error, and the fourth bullet is it doesn't fall within anything even close to similar error. And there's case law on similar error that's very strictly narrow to called the face of the award. On the face of the award, does he say something like, because the sky is blue, something that's, crazy, that just is so inconsistent on the face of it. I think there is something like that in the award, but it's sort of disfavorable to us, right? Isn't there some inconsistency in the award that disfavors us?
Well, the inconsistency is that it's not clear whether he's subtracting their $1.4 million restitution payment. I mean,
right.
I think we're all assuming it is. But I mean, he said that he wasn't, that wasn't before him. But then when he talked about the interest calculations, he said you stop calculating interest once they paid it. So that implied that it.
Right, but you still get to the 3 million number. Even after you take that offset. So it's not like John is getting some advantage there.
No, you're right, yeah.
But keep going after 24. Let's look at 25, enforcement. Proceedings to confirm control conducting performance. Consent. Okay. All right, so that doesn't really speak to it. And then this is really what you might say is where you could really amp up the draft I wrote, you could say the parties may agree at any stage to submit the case, blah, blah, blah. The parties may agree to actually embody in a consent award. So why don't we put the punitive damages concept in a consent award and say we figure out a way to short circuit phase 2? But how do you get to that outcome without the other parties objecting, right? Like, think about it. We say, in fact, Judge, we're going to give you the final award for you to enter by consent. Won't the other side just say, we're not agreeing to those punitive damages? We say, that's fine. We got 2 of the defendants that are. So then scratches his head and say, well, what do you want me to do as to the other defendants? What happens with them? And what happens to these entities? Like, should be in this? Should be in this? Like, is tech? The other guy is not. There's 4 others.
Stay tuned for part 2 of this episode of The Valley Current.